Does anyone ever watch the live stream meetings?
We were just talking about that. Not generally, maybe 3 or 4 people.
Yeah, at least you get a couple.
But we feel like it's important to say, well, you could have.
Yeah, good point. We've been debating because we are open meetings also. But the AOC is not necessarily as welcoming to guests as we used to be. So we've been talking about moving to live streaming. I don't know if anybody would actually jump on though. So
not really, not a lot so far, but
yeah,
they can if they want.
Fair enough.
We're just waiting for Gina. So does anybody on here fly Frontier very often?
My children do, but I don't.
Yeah, I got home from Atlanta at 2 a.m. That was not the original estimated.
Yeah. I had one of my son's girlfriend was supposed to go to California and they just canceled her flight. I mean, just with nothing.
Yeah, it was a mess.
So I've been on the receiving end of trying to help reschedule those, which was no fun.
Yeah, I've not heard very many good stories with Frontier, so I've always tried to stay away.
I recommend Scott's Cheap Tickets to look
Is
on
that good?
Yeah, they send you daily updates of what's cheap, and it's a very good way to source those.
Well, I like that. I'll have to remember that.
I go back and forth to Atlanta a lot, and usually it's not a big deal, but yesterday they were canceling flights right and left, so I was lucky to get home at all. Okay, Jean, I'm sorry. I didn't recognize it says Lauren Leader on it.
Oh, she's one of the lawyers in my office. Sorry about that.
That's why I was like, I don't know who that is. Jean has actually been there for quite a while. I thought she was an interloper, so I didn't let her in.
Sorry about that. Okay, we got everybody but me now that I'm here.
I think that's everybody.
Okay. Good morning, soon to be afternoon. Members of this subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest in the appearance of conflicts, and are instructed to refrain from participating in a matter coming before the subcommittee with respect to which there's a conflict or an appearance of a conflict. I don't expect that we would have any of those. So I guess where we need to start is with Tara or Sarah to walk us through the new revised leaned up mediation agreement.
Yeah, I'll get started. Absolutely. Because I know that Sarah and Dan and I have been working on their own. So we've kind of got an interesting dynamic because Sarah and Dan and I have brought this to the commission's attention, but they're not on the committee. So they've got their own version, which after reading through it this morning, I think is pretty much along the same lines as the version that the committee came up with. So I think that there may be 1 or 2 questions that Sarah and Dan and I have specifically for the state bar. And then I think the rest of it is just potentially, if upon your approval of what we're looking at, is just kind of pounding through the language or terminology within the different provisions. But what we did at your request is try to create a lean document that literally contains the provisions that mediators would not be able to draft into their own document. So we're trying to take the language that would get a mediator in trouble by offering this in a service contract for their parties. We're trying to pull that language out, put it into the one-page document to address whether you want to call it inability to compel testimony or inadmissibility of negotiations. It's more or less the same language. But we're trying to provide that safety net there for the mediator and for the parties to indicate that there is no recording of that mediation and that the confidentiality will be a part of the process. So those three things are paramount to any mediation that is conducted. And when you're not mediating under the rules in the statute, it doesn't automatically apply. And then confidentiality, of course, does not apply to the parties of any mediation unless they draft up their own documents. So what we're trying to do is to provide guidance for citizens to be able to enter into safety language, walking into a mediation without having to hire an attorney and sign into these different provisions. I don't know if you all had a chance to read through it, but we took out all of the options that we had listed in the 2-page document we reviewed last time. And we also tried to clean it up and make it more concise.
I've got two sort of substantive questions about the leaned up agreement. My first question is, in the confidentiality of the mediation section, second to last sentence, you talk about the provision, confidentiality does not limit a participant's ability to file a complaint with a regulatory body governing any participant to the mediation. And I'm wondering a couple of things. Number one, what are we talking about? If we are talking about, for question number one, what is that designed to deal with?
So I actually went back and listened to the meeting minutes that the committee and the commission had regarding this document this morning. And the last couple of sentences within the confidentiality section, we had quite a few different people who felt the confidentiality section was almost too strict in the sense that it would not allow someone to file a motion in court if the original mediation ended in impasse and somebody took it to litigation, that the way that we originally had it written, it would preclude a party from filing a motion saying they've already attended mediation and asked to waive any future order to mediate under MSC or FFS rules. So they felt it was important to add in the last couple of sentences to make it clear that what is and is not confidential. And I think the way that they were discussing this in the meeting is they wanted to make sure that anybody who signs into this contract does not believe that it is the end all be all absolute. So without giving legal advice, they're saying that trying this method of ADR does not prevent you from seeking further action in court.
Okay. Well, the last sentence of that paragraph, the mere fact that mediation is occurring or has occurred and the terms of this mediation agreement are not confidential. So that certainly addresses that. Yeah. It's the sentence before that that's given me pause, and it's this language about filing a complaint with a regulatory body governing any participant to the mediation. Well, you wouldn't, the only regulatory bodies that would be implicated by mediation, I guess, would be the state bar for a grievance against your lawyer, or a grievance against the mediator, which is what I'm afraid people are going to think about. And of course, we want mediators to have immunity. And so I feel like that language is inviting trouble where trouble doesn't occur. And so I was wondering what problem you were trying to solve by adding it.
I mean, the only thing that I can kind of relay is that they wanted to keep that in there to make sure that people understood that they still had rights outside of the ADR process. And filing a complaint against a mediator, mediators are always going to be bound if a mediator is certified under the Dispute Resolution Commission, they are always bound by the standards of conduct, no matter what mediation they hold, whether it's under the MSC rules or whether it's a voluntary mediation, which most of these will go for. So the statement in there would address anybody's concern about their ability to take action if action needed to be taken.
Well, now that I'm looking at it, I think we've got a problem because in the first paragraph, you specifically define mediation participants as not including the mediator. And so this language down here in the confidentiality, you say governing any participant to the mediation, which wouldn't be the mediator.
I think you're looking at a different document, and I apologize about that. We've got two different documents. The one from the commission is the agreement to mediate. And
I'm looking at the little mediation agreement.
No, the mediation agreement is Sarah's and Dan I's.
Okay.
So the commission wants, and Sarah and I had a really good conversation the other day, and she asked me off the cuff, hey, do you like mediator signing agreements? And I said, no, not a big fan of it, but this is kind of my personal take on it. And then, of course, I went back and listened to the commission and their statement on it, and they want the mediator to have the option to be bound by this agreement to give them the same protection that we're giving the other people. So having a mediator as a participant was intentional by the commission in the agreement to mediate.
Okay, so I'm messed up. I'm looking at the wrong thing. Let me see if I can find the right thing.
But a lot of the language mirrors each other between Sarah and Dan I's and the one that the commission provided. A lot of it is, I think Sarah and Dan I did a really good job of making it prettier and clarifying some of the sentences in there that we can definitely take back to the commission to clean up. But that was one of the differences.
All right, now I'm looking at the right one.
So just to make sure I'm looking at the right one, is this the one that was sent out, I think on in late July?
Yes.
As an attachment? Okay, that's the one I should be looking at.
Yes.
Okay.
Yes. And it should say agreement to mediate at the top.
There are two, the DRC approved one. Dana and I weren't part of that meeting, but they approved one that is the agreement to mediate. When we got the agreement to mediate, Dana and I proposed some revisions. So that's what's in the mediation agreement. So that's the difference. We tried to keep what the DRC had and just make some additional suggestions to try to deal with a couple points that are identified in the email that Dana and I sent to Suzanne last week. Gina, addressing your concern, the sentence that you're discussing was one that was added by the DRC, not one that was original to us, but we could probably get rid of the discrepancy by simply removing the phrase governing any participant to the mediation, and then it could just end with their own attorney or file a complaint with the regulatory body, period. And that would get rid of that inconsistency.
The other question that I have, and this is probably coming from a mediation ignorance standpoint, but in both versions, in the agreement to mediate from the DRC and the mediation agreement from you, it refers to limitations of testimony in anticipation of a mediation. What are you talking about there, and how would that be protected?
And which paragraph are you looking at?
It's in the DRC document. It's in protection from compelled disclosure. And it talks about one of the things you can't compel is conduct or statements made in anticipation of the mediation. And that in anticipation of language is also in Sarah's document. So
I'm sorry. Yeah. So the mediation, and maybe it's just bad word choice. So the DRC defines mediation as the entire process. So it would be in anticipation of the conference itself, but it would apply to the scheduling discussions and discussions about reviewing documents before you get into the conference. So it may be that we just need to clean that up a little bit and remove the word of anticipation and further define the whole mediation process as before, during, and after the conference as it's defined in the standards.
Okay, so
And-
it's just
and
about the logistics.
I think that's true, but it's very common for mediators. And for instance, my practice requires most of them on pre-litigation mediations, a conference with the attorneys or with the parties often before the mediation begins to understand if there's any barriers or issues that might come up. So we do have substantive conversations, possibly after documents have been sent, but there are very substantive conversations, ex parte conversations that mediators routinely have with parties and with counsel prior to actually walking into the mediation Zoom or physical section. So, the understanding of the process, I think, covers that. And also, once you leave mediation, sometimes you're still working on material issues about documents or other things.
Well, the way the language is currently drafted in both documents, it would sweep in lots of things that are not contemplated by what you just said. So I think as long as we make it clear that it's the conversations about the mediation process and the rules that are going to apply or something like that, it would be okay. But now it would be sweeping in things that would be clearly not protected.
I think we can do that.
Just as an example, Gina, when we're building up towards a mediation, we regularly send the mediator an email with the pleadings, with our summary of important facts and issues, and we do it with the expectation that's not going to be shared with the other side, and the instruction is not going to be shared with the other side. So I do think that whatever we draft, it needs to encompass, and we're not alone. That's a pretty common thing, at least in Superior Court, Civil Superior.
So that's like a pre-mediation submission to the mediator.
Correct.
Okay.
Yeah.
Other than a pre-mediation submission to the mediator, can you think of any other statements or conduct between the parties that should be protected?
Well, I mean, yeah, sometimes we have a phone call with the mediator to explain things as well. But it's all meant to educate the mediator about the case, the issues, the parties involved, the personalities, so that they're more prepared stepping into a mediation.
So the language as it's currently drafted in both documents doesn't just deal with parties communicating with the mediator. It deals with parties communicating with each other and everybody else. Can you think of any scenario where you would need something protected that was not a communication to the mediator?
I mean, I suppose there can be examples of attorneys talking with one another, about issues leading into a mediation. Perhaps you have some settlement discussions that predate the mediation, but are sort of meant to, I mean, for example, I've had occasion where we provided an initial settlement demand before mediation so that we can sort of hop into a mediation with a demand on the table and make it more efficient time. But that would still be discussion between the attorneys.
Well, and that's protected under the settlement negotiation rule.
I think that's right. And I suppose in an unusual situation, you could have pro se parties who are having pre-mediation settlement discussions, but I think you're right. That would be covered by Rule 408 anyway. So
I have a comment too. I just have a couple of questions, and I apologize if you've already addressed these before, but it does go to your question, Gina, about the breadth of this paragraph. So, a judge can also sanction a lawyer who is a party to, a mediation and who engages in unethical behavior. And the way that it's currently drafted, it says that, information about that behavior can only be shared with a regulatory body. So that's the first comment I want to make to the group, and see what you guys want to say about that. The other thing that I've experienced is that, while statements made at the mediation are not admissible, if you learn information from the mediation, of course, you can use it later in the representation. And then also sometimes, and I've had this arise personally in my own practice, there are questions about whether an agreement was reached or what the terms of that agreement were. So the other concern I have about the agreement overall, and this would be paragraph 1 and potentially 4, is that it does not, it said, and a mediator would be called to testify as a fact witness potentially in a scenario like that. So it doesn't seem to allow that to occur without a court order. And that feels more stringent than the rules actually currently require. So I don't know if you guys have talked about that before and I missed it, but I just want to raise those issues.
Ashley, I apologize. You froze on my screen when you were giving your last example, and I'm not quite sure.
Okay.
What you're
I
looking
think
for.
that was about how sometimes there is a dispute about whether a settlement was even reached or what the terms of that settlement were. And in that scenario, it's possible that the mediator could be called to testify in court as to the terms of the settlement. And so I'm afraid that, I think the title on paragraph 1, inadmissibility of negotiations, is correct, but I think the language in the paragraph is perhaps too strong. Because the language in the paragraph says that you can't call someone as a witness without a court order, and that is not what the current rules would require of a mediator. So this just, I think if we're doing a sample, it should not exceed what the current rules require, unless, there's a different feeling in the group. But a mediator can be called now as a fact witness to testify about whether there's been a settlement and what the terms of it were.
But it's very limited on what they can be called to. And it's typically if a settlement agreement has been signed, not necessarily the terms contained within that agreement.
But that's not necessarily true. I mean, if it's a Superior Court ordered mediation under the rules, and I think by statute, it's got to be in writing to be a binding settlement. But it's not necessarily true in some contexts that you can have a settlement agreement that is reached, but not yet put to paper. And Ashley's right that the mediator can be subpoenaed. I've seen it happen to establish the terms of that agreement so that that agreement can be enforced even before there is a writing. And I agree with Ashley. I actually raised this issue in our last meeting.
And I respectfully disagree. And I respectfully disagreed last time. Like, even though you may have seen it happen, all of my training, and I'm pretty sure my commission would back me up on this, is that it's very limited on what a mediator can be called to testify about. Whether it happens or not in real life is something that's kind of outside of my bailiwick. And I've seen some crazy stuff too by judges. And we always tell our mediators, if a judge tells you to do something, I don't want you to land in jail. So you've got to kind of comply with the court. But if you look at the statute, it's very limited as to what a mediator. It's no mediator, other neutral or neutral observer present shall be compelled to testify or produce evidence concerning statements made or conduct incurring in anticipation of, during, or as a follow-up to a mediated settlement conference or the proceeding in civil proceedings for any purpose, except to attest to the signing of any agreements and any proceedings for sanctions. So the statute's very, very narrow. It doesn't necessarily mean that it's always followed. And so the commission, when they drafted this, tried to make this one-page agreement like a mini blurb from the statutes and the rules that are provided.
That's helpful. I didn't know about that. But
Yeah.
But as to what about the sanctions issue? Do you think that this allows you to call somebody for the sanctions question? And that was actually the first issue I raised, which was that the court can issue sanctions. And this only, I thought I read paragraph 4 to say only a regulatory body.
Yeah, and I don't know if the commission, when we were looking at this agreement, really took into consideration sanctions, partly because it's a voluntary mediation that this is going to apply to more than anything. And if the parties do wind up in Superior Court or Family Financial ED matters into mediation, then the rules are going to override and kind of govern the court-ordered mediation as they're written. So I think, if you're looking for sanctions, you've got to have some kind of litigation in place. I suppose it's absolutely possible, though, which I'm pretty sure that we didn't discuss, to be under this agreement to mediate on a matter that is not in court ordered mediation where sanctions may apply. So maybe that's somewhere where we need to broaden that a little bit.
Here, I had a question. That
Yes, sir.
statute that you read,
Mhm.
is it your take that because it's a matter of statute, if they say a mediator is subpoenaed to a hearing to testify about the terms of a settlement, and a judge is handed a copy of that statute that you just read and says, but in my discretion, I'm going to order that the mediator still testify as to the terms of the settlement? Or is it your view that a judge legally cannot, in his discretion, order a mediator to testify about something that's specifically prohibited by statute? Is that what you're saying?
That's what I'm saying. Now, again, you know, people get subpoenaed all the time. So people call my office all the time. They're like, holy cow, Terry, I just got a subpoena. And usually when I talk to the person who issued the subpoena, I can kind of walk them off the ledge, you know, but it happens, you know, and I would love to say we're a unified court system, but we're elected officials as judges, and it is what it is. So we do the best that we can every day. And Judge Bell's nodding. I can see that. I love it. Yeah. So, but the judges that are on the commission, they would take a very strong stance that that statute will protect mediator.
You're
Okay.
muted, Julie.
Nope, still can't hear you.
I did have another question about the confidentiality part, but I will wait till we're done on this specific aspect.
Julie, can you unmute?
See her chat?
Yeah.
Hey, Judge Bell, can you type what you were going to say? Because we can read that. It's probably long.
I don't think I can do anything because it doesn't show her as muted on my screen.
Okay, Lamar, let's switch gears. What were you going to say? What was your other point?
So my other concern is, as it's written, I'll just give you hypotheticals to illustrate the concern. So we're in a pre-suit mediation. Everybody signs this document. During the mediation, one of the parties discloses some document that exists or says it's this document exists and I'm talking about it. I'm not going to give you a copy of it, whatever. Mediation impasses, lawsuits filed. Someone sends a document request saying, hey, produce this document for me that I know exists because I heard about it in the mediation. And then the response that person gets is, no, you signed this agreement saying that everything disclosed in this mediation is confidential. So guess what? You now don't get this document. I would hope that judges would see through that and say that that's not what was intended by the scope of this agreement and whatnot. But I can see that argument being made from a mile away. And so unless there's some prevailing reason why that can't be the case, I would think that we would want to make clear that it doesn't inhibit anybody's rights to discovery if and when a discovery is appropriate or whatever.
So Lamar, I don't read it that sweepingly. I read it as just talking about statements made and conduct occurring in the mediation process, and the evidence is not captured by it. Tell me why you think it's broader than I think it is. You're looking at the agreement to mediate, right?
Yeah, well, I made the same mistake as you. I was looking at the other one because I assumed that the latest one circulated was the correct version to use. So, but I'll try to transition over to the agreement to mediate. Looking at that one, let's see here. Yeah, I mean, this may be different in the agreement to mediate, but the mediation agreement version says participants agree to keep confidential all information communicated during the mediation process. And Gina, I'm with you. I would not read that as broadly to include limiting someone's rights to discovery, but I could see the argument being made that no, all information includes the information that this document exists, which you obtained through mediation.
Yeah, we definitely have to clear that up. I mean, that has to be clear, that the mediation blanket is not a blanket that precludes evidence from being gathered.
I think it would be very simple to put in there. And I see what you're saying, because it does say that we keep confidential all information communicated during, but we don't define what information is. We do state that it includes statements and conduct, but we don't necessarily provide that protection for discovery. I don't think the commission would have any problem putting in there that putting a disclaimer in that paragraph that it doesn't inhibit anyone's right to discovery.
Well,
Yeah.
and I used the example of a document, but you can play out the hypothetical with interrogatories too, right? Where
Mhm.
Right.
tell me
Yeah.
about this thing, and then the response is, no, I don't get to answer that, because the only reason you know about this piece of information is because of mediation.
Really thought about making that revision, because we do, when I mediate, I often have attorneys that want to exclude that just because something is stated in the or shown in the mediation doesn't mean it's not discoverable. And I think we absolutely could add in that clarification. I didn't in our revised version, in part to try to keep it on one page, but also in part because our goal with the mediation agreement here is to have a document that does not require parties to interpret it or for the mediator to give legal advice. That's the primary reason why we're here. And so my concern with trying to use the word discovery is that then you would need to define discovery, because parties don't know what that means. So if there is another way for us to say that, all in favor of that. I think that's a real issue, but the vast majority of people reading this won't know what that means.
How about fact finding?
Well, or just simply, this agreement doesn't in any way inhibit anyone's rights to obtain documents or information according to rules if a lawsuit's filed, something along those lines.
Yeah, I have something like doesn't inhibit anyone's right to access discovery or to obtain discovery if the matter moves into litigation. So it would be further vetted and defined completely. So, I mean, the idea is that we try to draft these so they address an eighth grader.
Yeah. Well, I think everybody understands documents and information.
Yeah.
You know, and I would say, and I appreciate you guys have done a fantastic job of making it one page, and I'm sorry to add a little bit to it, but my concern on behalf of the state bar is if an unintended consequence of this is waiving folks' rights to discovery, then we're asking them to do that without anyone, at least the pro se parties, understanding what they're doing and waiving those rights. So I don't think there's any way around having something in here that says that.
I think we can add something in, and we'll try to use language that doesn't do that. And I think you're exactly right that as I said, that's something that we thought about. It is, and it's so hard because we're trying to create a form that will also work, say, in church mediations where there's no contemplation of litigation whatsoever. Again, to meet the state bar requirements around mediators not drafting. So finding language that works in all of these settings, I think it's really challenging, and frankly may make a good case for the fourth bullet point Dan and I put in our email, which is that it would be really great if we could kind of have something. An AOC form is great, but it'd be also great to not be so locked into specific language that it can't easily be ported into a different setting.
So and I understand Sarah's concern, and I've been working with Sarah and Dan on this for a long time now. We've been working for at least a year trying to find the perfect solution. But I do feel like I need to let you all know that when I started talking with Brian Oaten about this, when it first came up, the whole reason why we went into a form document was because he basically warned us against having a mediator create a document that provided a cause of action between the parties to the document. And so what we were trying to do is to peel out all of the things the mediator could not draft in their own agreement and put in a form that could be published by a governing body like the AOC, because the parties, even though they're adversarial in their suit, are not necessarily adversarial in coming to the terms of the mediation. So it was very much seen as like real estate documents. So I just wanted to kind of clarify that Sarah and Dan have definite specific needs for what they're looking for, but the commission's going to kind of step back on this one and let you guys work with them on this, because it's not something that the commission wants to step in. So we're going to kind of let you all talk to them about that.
Yeah, and Sarah, I think therein lies the rub, right? I mean, that's the problem, is to once you start trying to tailor it, you are practicing law and drafting. And the idea would be to insulate you guys from doing that.
Will it be
Sorry, I was going to say, Suzanne, you've been mighty quiet. What say you, since you
No, I
know
mean,
more than the rest?
it's just a very difficult task. I was looking through both of the drafts, and I was just trying to think about how you're going to just hand this to somebody without any explanation and expect them to understand it. I mean, and that's basically what we're trying to do. And it's not easy.
I have a question, which is, has the committee thought about a misbehaving mediator yet? And so, a mediator who could sexually harass the participants or do something otherwise untoward during the mediation process. I just wonder what the discussions have been about that.
Well, like, we've got a mediator who is like engaged in this contract who behaves completely inappropriately.
Yeah, with one of the parties. Yeah.
Yeah, fair enough. So the standards of professional conduct for mediators apply constantly throughout. It's kind of like being an attorney means the rules follow you everywhere you go. So even if you're mediating outside of one of our court order programs and in a voluntary mediation, you are still bound by the standards. And we've got standards that would prohibit that type of behavior. And so we could go after the mediator.
Can the and under this agreement, that's very helpful. Under this agreement, the parties, I don't think they could unless we add that civil action again. And I know Terry, you're thinking about that. So I was just wanted to mention that too. So down there in that sentence that says you can only file a complaint with a regulatory body. Because there could be a civil action. I'm just trying to think of all the different things that could happen. There could be a civil action.
But it wouldn't be out of the same cause of action that the matter is about. So that's
correct.
I think that's the difference.
But what about the ability to say what happened? Agree. But what about the ability to say, this is what happened at the mediation? This is what the mediator said to me.
But I think if it's and maybe that's a good question. Judge Bell, do you have volume now? Maybe this would be a great question for you.
I think I got volume. Can y'all hear me?
Gotcha. All right. So here's the question, is that the confidentiality provision limits disclosure or sharing information from any civil action arising from the issue being mediated, right? So if you're mediating equitable distribution, because that's just the easiest one for me, and the mediator decides to be a real loser and decides to sexually harass one of the parties, does the party who's being sexually harassed have the ability to file a harassment suit against the mediator and disclose information from their conduct and comments at the mediation? My inclination would be that would be okay because it's a different cause of action.
That would be the way I would interpret that, but I don't know that everyone would interpret it that way.
Right. So maybe that's something that we go back to the drawing board with and take a closer look at and say, okay, is this really going to protect the citizens? Because That would be bad. And while we haven't had it happen, knock on wood, hopefully it never does.
Well, and you also may have a non-certified mediator, right, using
Yeah.
this. So they wouldn't be subject to all of those other standards. So I think it probably is something for us to look at.
So there's a specific sentence in the middle of the confidentiality of the mediation paragraph in the agreement to mediate that says other exceptions to this confidentiality provision include any criminal conduct, acts of violence, or public safety issues that occur during the mediation process.
But it makes it only admissible in criminal court action. So that would not help you if somebody was bringing a civil action, a separate civil action.
Agree. I'm just saying that's a perfect place to add a few more words to capture this problem.
I got you.
Yep. Let me put it up there.
Because I would want it to be admissible. I mean, sometimes, particularly, today was a perfect example. I had a hearing, and since it's over, it's not pending anymore. So I can discuss it. I had a hearing where one side could not present what they needed to present. They should have prevailed, but they couldn't present what they could, and I can't be their lawyer. And so I can only rule on what is in front of me. And then that party got very frustrated about the situation and acted inappropriately and found themselves in lockup for a little while.
Wow, it's been a big Monday morning for you.
But yeah, but you're bound by the rules. I was very frustrated with that particular matter because I knew what should happen, but what I felt very much bound to do was to follow my oath and do what the evidence required. And so that's what I did, because that's what I'm going to always do. But so you don't, I guess what I'm lobbying for, I agree with that we should put some additional language so that people can have some something to hang their hat on.
Yep. And I think we can figure that out. Absolutely.
May I ask a question back on the issue of how the form will be used? I wanted to clarify that Dana and I weren't proposing that we would modify the language in the specific paragraphs, only that we would be able to take paragraphs that were written from this document and be able to put them into documents that provide for the context of the mediation. For example, when I do a church mediation, I'm helping people inside a church try to resolve their disputes. They may want their mediation to be confidential. Nobody's contemplating any legal action, even within whatever that denomination's judicial system would be. But they do want to have their mediation be confidential. I would love to just be able to take whatever the paragraph is from the form and put it into a document describing what church mediation looks like with scripture references and things like that. And this is actually the setting that originally prompted this question, because I had parties that wanted to do that and asked me to put that into a document describing the mediation process. So that's what prompted me to ask the bar this question originally. But that setting is, of course, very different from most of the settings that we're talking about here. So I wouldn't want I would take the whole paragraph and put it in, but I would want the ability in a completely different context to be able to use that language without violating the ethical rules of the bar as an attorney.
And I guess I don't know what a church mediation contract would look like and how it would in no way, shape, or form be a legal document. It's just a tell me what it looks like.
It looks a lot. Yeah, good question. It looks a lot like the form that Dana and I originally presented, where it's just describing mediation process, what the mediation process looks like, and then giving the parties optional terms. And it would add scripture. It would describe the Lord as the mediator, things like that. So, I mean, it's a different context. But otherwise, the piece of it that involves confidentiality, the parties still want that to be binding. So where I run into trouble in that sort of context is saying, I can't draft anything for you. And the way I'm dealing with it now is simply to say, you'll have to write it and do it yourselves, which is hard in a context like that, where I've got no attorneys and nobody that does that.
Wow.
Yeah, that's tough. Gina, do you want to look at the documents from the top? Like, I think we even have had discussions about the title, and kind of start at the top of one of these and kind of go through or pick out what everybody agrees on, if there is anything that everybody agrees on, rather than kind of jumping around.
Yeah, sure. Okay. I think that with respect to, so Tara, are you telling us that you think we need to be working off of the agreement to mediate as opposed to the mediation agreement? That's the impression I got.
So what I'll tell you is that this is kind of the commission's document that we're trying to provide. But unfortunately, I don't think that the commission and what Sarah and Dan and I want necessarily align completely. We're pretty close, but not exact. Most of the differences between the documents are non-substantive changes. But the agreement to mediate is the one that the commission has voted on most recently, that I have the authority to present to you to say this is what the commission is looking at. I'm happy to take more changes back to them, but if it's going to be a DRC document, it needs to go up through committee and full commission.
Well, I think one of the biggest differences, of course, is whether or not the mediator's signing it and whether or not the mediator's a mediation participant, right?
Right. So are we starting at the top or the bottom?
Well, I was starting at the top because the first thing it says is the participants to the mediation agree. And so that's the biggest difference you'll have, or one of.
Right. So the reason why the commission named it agreement to mediate is because we look at mediation agreements as agreements that are done as the final document in the mediation itself. So we needed something to kind of clarify, and it got really confusing at the beginning. So the commission is pretty steadfast that if we create a pre-mediation document, it needs to say agreement to mediate, indicating that we are looking at the terms that the mediation will be held under and not the final agreement that comes out of the mediation.
That makes perfect sense to me, and I agree with that thinking. Anybody disagree?
I think we could probably come up with an alternative title. The issue, I think, the concern I had with agreement to mediate is that this document isn't actually what's leading the parties to agree to mediate. These are just terms around these certain things. So, and I'm not crazy about mediation agreement either. What this really is an agreement about the mediation process. So it's certainly possible that we could come up with an alternate title that really gets at what it's about, which is the process, the guidelines for the process.
Because most mediators are doing an actual agreement to mediate, like with the fees and when you're starting, that type of thing, right, Sarah? That's what we're trying to distinguish between the sort of process agreement.
Now, our experience coming out of a mediation as mediators typically is the agreement coming out of that is the settlement agreement, or a summary of the terms for a settlement agreement, which is why we weren't as bothered by the title mediation agreement, but I'm perfectly happy to call that a third option. In fact, we even looked at pre-mediation agreement, but that really didn't do it either. So
It seems like the title should be more descriptive of what it actually is, which is an agreement on the terms or the process. I'm not sure what the best way to say that is.
Agreement for mediation process. Does that do it for everybody?
I like it.
Yeah.
Okay, I think we've all agreed that it captures every kind of category. Is there any argument with voluntary pre-litigation court ordered in pro se? Okay, so now back to where I wanted to start, which is this issue about who the participants are. So Tara, if you can tell us about the importance of the mediator being a participant.
So the biggest concern is that if you are mediating a voluntary mediation, the rules and the standards or the statutes don't apply, the standards do apply. If you are not mediating under the rules or the statutes, then you don't have certain protections that are provided within the statutes, such as judicial immunity, et cetera. So by saying that the participants agree not to call, subpoena, or otherwise seek to compel the parties to the mediation, if you don't include mediator, it opens the mediator up to being compelled to testify about all of those things if you're not a certified mediator under the rules or the statutes. So the whole trick of including the mediator as a participant is to protect them as well as the parties under the provisions that are being provided in this agreement that will most likely be used for voluntary mediations. And that also speaks to why the commission wanted to have the mediator as a party, as a signature to the agreement at the bottom, because they want to be bound by the same protections that the parties are being bound by.
Well, and you know, we're coming into this, I believe, from an access to justice perspective, and we want more people to be willing to mediate and serve as mediators, and they're not going to if they think they're going to get caught up in the crossfire. And if it's too big of a headache, people are just not going to do it. So I'm all for giving the mediators whatever protections we need to be giving them. So if making them a participant is the only way to do it, then I'm in favor of that.
So I think I'm definitely in favor of the protection as a mediator. My concern is that we've all spent, from the bar's perspective and the DRC's perspective, spent so much time trying to train mediators not to draft things. And by putting a signature line on this contract, I mean, mediators just don't routinely sign anything. I think most people refuse to. So I'm just wondering if we're sending some sort of inadvertent message about mediators in, contracting with the people who they are mediating for, which I think we've all tried to stay away from.
That's the issue that I have. I mean, if it's just the two parties are agreeing to the terms, that seems different than the mediator and the two parties agreeing to the terms. And that bothers me for some reason.
It feels contrary to what we've been at least training people, at least trying to get mediators to think about and not do.
Well,
and I agree with that. That's why we talked about the form versus the contract idea. But I hear you.
Yeah, I mean, the whole thing is contrary. I mean, it's contrary to everything the DRC has ever been, right? So you guys are kind of taking us out on a ledge where we're trying to protect mediators when they are not mediating under our programs, right?
Which is happening. Which is happening regularly. I mean, it's
right, but that's it.
Yeah.
That's at the mediator's choice, right? So we're trying to provide protections to our certified mediators to keep them certified. Because as Sarah and I have had this conversation many times, I've told her that her best interest is to decertify so she can go conduct the kind of mediations she wants without violating any of the DRC rules. I don't want to lose Sarah, right? That's not my goal. My goal is to try to find a way to be all inclusive of all mediators. But the commission's objective is to protect the mediators and provide services to North Carolinians. So if there's a way that we can do both, we're going to be more comfortable. But this isn't, I'm going to have, let me just put it this way. I'm going to have a really hard time selling it to the commission that we need to remove mediators from this agreement, because our whole goal is to regulate and certify and protect the mediators who serve North Carolina. So by removing mediators from the ability to conduct these mediations, but be immune from being called to testify, is going to be problematic from the commission side.
What if you put third-party beneficiary language in there?
That's what I was just going to say. My understanding has always been in these that I was the third party beneficiary, and I never worried about that because, and I mean, I've done this for a long time. I've never had one of these cause a problem, knock on wood. So yeah, I mean, I think we could just name the mediator as a third party beneficiary without being a signatory.
Because from the bar's perspective, I mean, we got this inquiry, and the fear of the mediators was that they're going to get in trouble with the bar because they're providing legal advice. It wasn't that we were going to protect them from, I mean, these other issues that they're facing, which of course are valid, but
Right. Well, when Sarah and I submitted the inquiry, it was kind of a joint venture to see if there was a way that we could protect the mediators as well as allow them to contract for these things without violating the rules, professional conduct, right? And unauthorized practice of law by drafting and all of those issues that go along with it. So there's multiple factors that go through this, and it's certainly complicated at best. We can take a look at third-party beneficiary language. I'm more than happy to keep kicking this around until we get something that everyone's comfortable with.
If I may ask a quick question, this may be wild, crazy idea, but why not just give the mediators the option to opt into it or not? Maybe have a addendum page that a mediator can sign if they choose to, say, and I hereby agree to this agreement to mediation process or whatever. And then that way you leave it up to them.
But how does that work then if the mediator doesn't sign it? Are they not protected now?
Hey, Judge, you know best. There's only so much you can do to protect someone who don't want to protect themselves, I guess.
I mean, I kind of agree with Lamar, like the version that the commission put up there had name for the mediator, but if the mediator just doesn't sign it, then the mediator doesn't sign it. And then if they didn't sign it, they're not, given those protections that are in it. I mean, there's no requirement that they sign it.
Yeah, but I don't want to get in a situation where we're not giving, I mean, we live and die by having mediation. I spend 3 weeks out of 4 in family court, and we have volunteer attorneys, thankfully, and I always applaud them and say, thank you so much for your volunteer efforts who come in and mediate with pro se parties and help us do that, as well as, the formal mediators that people deal with as well. I don't want to do something to take protection away from folks who are helping us get cases resolved, because they have pretty good success.
And I agree. And I think that anything that for attorney mediators, I think that if they feel that there's a risk from the Bar Association, particularly for doing some of these volunteer things of not being protected, that you're going to have less people. I mean, I like the third party beneficiary thing if we can do that, just because I think it's cleaner and it's more in line with what we've really been training everybody, but I will defer to y'all. That seems to get to everything.
And it avoids the third party beneficiary across the board without the mediator having to sign, avoids the feeling that the mediator has that this is a conflict of interest, where I have my personal stuff invested in whether the parties sign this agreement or not. I mean, yeah, that's where we kind of get caught between the bar rules and the DRC rules and the practice. We just get caught. My primary motive here, also to be frank, is that I kept running into problems where the DRC rules are saying parties need to have the ability to you need to tell them, what their rights are and that they have the ability to enter into things, but then on the state bar side, not having the ability to actually implement what the DRC needed us to do if there weren't attorneys involved, which is also an access to justice issue. So, and in a lot of these situations, I love that you all are thinking about it also from protecting the mediator, because the mediators are getting caught in the middle.
Sarah, let me ask, would the idea with a third-party beneficiary language be to say specifically third-party beneficiaries, including mediators? Like, go ahead and name a mediator as a third-party beneficiary, rather than just say third-party beneficiaries without describing what that means?
I think you would have to describe it a little bit.
Yeah.
I think North Carolina law requires a third-party beneficiary to be stated. So I think we would have to say that the mediator is a third-party beneficiary of this provision. and
I'll
just
defer
do it
to you
as,
guys. I've never
Yeah.
once mediated other than my kids fighting. So I will defer to those of you who have mediated and as to what is more palatable and comfortable for the mediators.
we just need to find language. If we're using a phrase like third-party beneficiary, we need to define what that means. All of that's really going to keep it from being a one-page document, because we've got to make it in English that people can understand without lawyers or the mediator getting questions about what something means.
Well, it's more important that it be thorough and clear than it be on one page. So, I think y'all did a fantastic job of taking it from whatever it was down to 1 or 2 pages to begin with. Unfortunately, we have to go because we had to find, Suzanne and Lenise had to work very hard to find these subcommittee meetings. But if y'all could, Tara and Sarah and Danae, work on those 3 or 4 issues and get something to us, we can meet again before, since we are meeting so early, we can meet again, I would think, before our October meeting. Right, Suzanne, or is that impossible?
Yeah, I mean, I think that was the reason we wanted to go ahead and try to meet this early, was with the thought that we would have the ability to meet again.
Okay,
Thank you so much.
I can do my best to get this up before the committees that I need to get it up through, so I can bring you back something formal from the DRC, because as much as I would love to say this is what they want, I really need their input on it. So hopefully I
Right.
can get, if Sarah and Dan, I can get me their language within the next week, I can set a committee meeting and get that to you with enough time to read. and hopefully
Fabulous.
on this one.
Just
Perfect.
We'll work with you, Dan. Dan and I will work with
Yeah.
you, Tara.
Okay.
at the risk of you guys being upset with me, very quickly, the last thing I would suggest is at the bottom, the bolded language, mediation agreement is legally binding.
Yeah,
I would add somewhere in there that this is the complete agreement of the parties
Okay.
related to the mediation process or whatever. That's sort of the thing that normally goes with the no oral modification clause. That way you don't get into any disputes about, oh, we also agreed to X or Y or whatever.
Got it.
Okay, thank
Thank
you.
you. All right.
Thank you.
Thank you, everybody.
Thanks, everybody.
Thank you so much, everybody. We really, really appreciate the time.
We really do.